Okay, welcome back, everybody. Welcome to clause by clause consideration of Bill C-10. We are in the middle now of a 5-hour debate, as was voted on by the House. We have approximately just over 2 hours left, and we're going to jump right into that. We left with 9.3. Just so that you're aware what 9.3, you did not get that in your original package. This is an amendment, a CPC 9.3, and the last three digits in your reference number is 641. Right, so that takes care of the hymn book. Now, last we had Mr. Jenis, who had the floor. He is not here with us now, but I don't see anyone who wishes to speak to CPC 9.3. No, then we will proceed to a vote. Shall CPC 9.3 carry? Okay, and carried. Ooh. This is a viciously efficient start we've got going here. I'm just saying that for the record. Since I'm on record for many other things, I might as well be on that too. Okay, that brings us to, now, there was a 9.4, but as you know, that falls later. Or no, that's not right. I think we're going to 9.5. Is that right? I'm going to check with the legislative clerk for just a moment. Mr. Miller?
Yes, Mr. Chair. Yes, indeed, we are going to 9.5 now because 9.4 was dealt with earlier at the previous meeting where it was asked for unanimous consent because it was not at the right place. So now we are at 9.5.
Right. So that was, if you recall, that was 9.4 was the motion that should have been placed prior to, and we did not get unanimous consent to return to it. So that brings us now to 9.5, and the last three digits for reference number would be 200. And to move that, I'm looking at Mr. Waugh. Mr. Waugh, the floor is yours.
Actually, I had a point of order here, Mr. Chair.
Sure.
I did do a notice of motion that went through the clerk yesterday, but I was wondering if I could move it today instead of Friday.
One moment. Okay, I can tell you it's not a point of order, but you can't move a motion on a point of order, Mr. Waugh.
Okay.
So I'm going to have to move on.
I was going to get clarification through you.
Absolutely. I'll give you that clarification in just a few moments if you wish, but I'm going to go to Ms. Ian right now. Ms. Ian?
Thank you, Mr. Chair. Just wanted to talk a little bit about 9.5. Is it okay to do that now, or?
Well, it hasn't officially been moved yet. We have to have a mover to do that.
I shall wait until it's moved.
Okay, CPC 9.5. So,
and don't worry,
Mr. Waugh, go ahead.
Yeah, go ahead. Sorry. Let's do it tomorrow. We're fine.
Okay.
We've got a long day ahead of us.
Yes. Oh, I'm glad you said that. As you know, everyone, we're having another session at 3:30 to 5:30 Eastern Time. You do not have the Zoom coordinates yet, but they will be emailed to you near the end of this meeting. Okay. All right. So the reason why you don't see it's because it hasn't been sent to you yet. Okay. Now back to 9.5. That is in our schedule right now at 9.5. Do I see someone who's moving 9.5? No?
Oui.
Oh, yes.
I see you, Mr. Ryan.
Monsieur le Président, je pensais que c'était automatique, c'est pour ça que j'attendais que vous me donniez la parole, mais je comprends qu'il faut que je le ressouligne officiellement. Donc, je vais essayer d'être plus vite la prochaine fois. Donc,
Mr. Ryan. So, if you could just very eloquently say the name of your riding so we can do a test.
Alain Reyes, Richmond Arthabaska MP, and I also am not receiving French translation when you're speaking, Chair.
Oh, well then I will do a test of my own. Give me the thumbs up. One. Okay, there you go. Where were we? Mr. Reyes. And the floor is yours.
Excellent. Thank you very much, Chair. So CPC 9.5 reads as follows: that Bill C-10 and Clause 7 be amended by added after line 14, page 8, or 19, page 8 in English. 9.2.1. The Commission shall, for each regulation or order made or condition imposed under this Act in relation to an online undertaking, I'm specifying that it's really an online undertaking, obtain an independent legal opinion as to whether any of the provisions of the regulation, order, or condition are inconsistent with the protections provided to Canadians by the Canadian Charter of Rights and Freedoms, particularly those relating to freedom of speech under paragraph 2B. And in a second section, the Commission shall publish the independent legal opinion on its website within 10 days after obtaining it and shall cause it to be published in the Canada Gazette. So if I may explain now this amendment that I'm moving, but just before I forgot to do this when I began, I'd like to thank you all for supporting 9.3, which we debated yesterday and which we voted on at the start of today's session. So this amendment is not very complicated. I think everybody can understand it. In all of this series of questioning regarding rights and freedoms and the Canadian Charter and the whole issue of freedom of expression, we wish to be sure that the Commission publish an independent legal opinion whenever decisions are made or whenever a new a regulation is proposed regarding online content, so that we can be sure that the rights guaranteed by the Canadian Charter of Rights and Freedoms are protected. So what we're saying is that this be published on the website and that this be published in the Canada Gazette at the same time, so that all partners and broadcasters, digital or conventional, and all Canadians know that the regulation is respecting the Canadian Charter of Rights and Freedoms. So I think this would be a protection measure that we would be giving ourselves as parliamentarians in Canada to ensure the protection of everybody's freedom. I think this is an issue. We know that this is going to be contested by legal counsel and lobby groups or interest groups. We can see this. We see university professors and lawyers questioning what we're doing now, and we understand what's happening with this legislation. And so with this amendment, I think we're giving an additional chance to improve the version that we have. Thank you, Chair.
And thank you. Mr. Shields, you have the floor.
Thank you, Mr. Chair. Appreciate that. As the amendment has been explained in the rationale for it, and very much appreciate that. But the department is with us today, and what I was wondering in the sense of what they would believe how this could work with the CRTC, as the CRTC they're familiar with, and the regulations they develop, and their undertakings to do with things they do now. Could they explain to me how they believe this is something we could do in the future as the CRTC would look at this piece to do with the work they do looking at this legislation?
I see Mr. Ripley has lowered the boom of his microphone, which means he's prepared to rocket fire go. Mr. Ripley, the floor is yours.
Thank you, Mr. Chair, and thank you, Mr. Shields, for the questions. So there would be a few things I would underline with respect to the amendment that has been tabled. The first thing is to highlight, and this was a point that came out in the committee's discussion with respect to the charter and freedom of expression, but to remind the committee that, of course, the CRTC is bound by the charter, and its decisions are already subject and will be subject in the future to review for charter consistency through things like judicial review of its decisions, et cetera, et cetera. Perhaps this may not be well known to the committee, but the CRTC is actually already served by independent legal counsel. In other words, its lawyers are not Department of Justice lawyers. So in that respect, the CRTC already avails itself of independent legal advice. The third thing I would note is, the amendment that is on the table would be quite exceptional in the sense that we're not aware of any other regulatory body that is in the practice of publishing its legal opinions. My understanding of the amendment is that the requirement would actually be quite significant in the sense that it would apply to each regulation or order or condition imposed on online undertakings, and we expect that those would be quite numerous. So at the end of the day, Mr. Shields, the impact on this would be that the CRTC, anytime it made a regulation or an order, would have to go and get a charter analysis done with respect to that, and then publish that. And make it available. And again, from what we have seen, that would be fairly exceptional in the current regulatory landscape. Thank you, Mr. Chair.
Thank you, Mr. Chair. Could I follow up?
Absolutely.
So in looking at this, when you first mentioned this, that would lead then to somebody on the outside, then if this wasn't in place to do that, take it to court and challenge what they haven't seen as a ruling. They would have to challenge it in the legal sense. So as this is new legislation, new grounds in the sense of what we're dealing with, would not they want to make sure that they're establishing groundwork? This amendment should cover them in a sense if they were to do this, as we're moving into new territory, and provide cover for what we think is going to be challenged by the outside anyways. Wouldn't this be a safeguard step as they're moving into it?
Mr. Ripley.
Thank you, Mr. Chair. Thank you for the question. The expectation is certainly that the CRTC, consider, the charter in making its decisions. And again, the CRTC already has a team of independent legal counsel that would provide that opinion. To your point, publishing those legal opinions would, obviously then subject them to external scrutiny. The question of whether that's a safeguard or not is a judgment call that I would leave up to the committee. Again, it would be fairly exceptional. This is not done when a legal opinion like that gets published. It waives solicitor-client privilege, and that can complicate matters as if ever there are court proceedings in this respect. Again, not to kind of go over the ground that we've already been on, but that's why, for example, the charter statement that's published as a bill is not a formal legal opinion in the sense, but rather an analysis of kind of how the charter is potentially engaged. And again, this would be fairly exceptional to require a regulatory agency like that to publish a legal opinion with respect to every decision it makes with respect to a certain kind of entity.
I very much appreciate your explanation and what your belief of how this could work. And that's what I asked for, was your opinion. I appreciate that. I think, in a sense of the amendment, as we've moved into this area, this legislation could possibly pass, that you try to look for all the safeguards you can find. We know it'll probably end up in court and challenged. So you try to find ways to protect as much as possible. As you go into new territory, and making sure that those things are protected. And there's as much legal advice and judgment ahead of time as possible. And I understand what you're saying about confidentiality, client confidentiality. I just, I think it's an amendment that maybe protects things from getting tied up in court and this getting tied up in court for years. And I thought maybe as an amendment, it might help that process along, because nobody wants to have a law and put in place and then all that happens is lawyers make money for years fighting things in courts and nothing happens and no money moves other than to the law's office. And that's the last thing you want to do when you pass legislation is to do that. So I think it's a protection and that's why it's there. And thank you for your opinion. Appreciate it.
Mr. Aitchison.
Thank you, Mr. Chair. And this whole discussion has actually made me wonder about a couple of different things. And I'm wondering if Mr. Ripley, I have a couple of questions. Starting with, do you know roughly what the legal budget is for the CRTC? I mean, are they frequently in court, or are they engaging lawyers regularly for the decisions that they make? Is it a problem?
Mr. Ripley.
Thank you, Mr. Chair. Thank you for the question, Mr. Aitchison. I don't have the legal budget off at the tip of my fingers. What I can say to you is that CRTC decisions are subject to judicial review on a regular basis, in the sense that there are applicants who choose to have that decision reviewed by a court. Some of those are fairly high level, high profile proceedings, and others less so. And again, that's why, just to reiterate that there are mechanisms in place, either judicial review, and there's actually another provision in the Broadcasting Act as well, that if a party to a proceeding feels like the CRTC has made an error in law or something along those lines, there's also a mechanism that it can have that decision reviewed by the federal court system as well. One thing that I would note, and perhaps it speaks a little bit to Mr. Shields' earlier question as well, is just to remind the committee that proceedings are subject to a public process, in the sense that anybody who wants to make a submission and put something on the record has the opportunity to do that. So again, when the CRTC is making a new regulation or an order, there would be an opportunity for organizations or individuals to make submissions, and if they have concerns about the impact of on charter rights, for example, they could make sure that is part of the public record, and then of course the CRTC will have to consider that in its decision making.
So if I may follow that up, Mr. Chair, I would understand then that in the past, CRTC judicial reviews or public hearings would they would be related to big companies, whether it's like Bell, for example, or TELUS, or those kinds of corporations. And one can only imagine how many lawyers would be involved in a judicial review for something that Bell Canada was interested in. And I guess I'm wondering about a judicial review process in light of what they will now have access to regulate and make decisions on. We're talking about not big corporations, but individual Canadians, smaller entities that aren't big corporations. I'm just kind of wondering about that process and what that might look like. If let's say I became some kind of an Uber star, which we all know would probably never happen, but let's say I did. But I actually make a decent living off of posting videos of me, gardening or something. And then I'm not a big corporation, obviously, but what would the judicial review process look like for individual Canadians who find some success on these social media sites and then become subject to regulation.
Mr. Ripley.
Thank you for the question. So a couple of things. One would be just to stress off the top, and again, this perhaps picks up on some of the committee's debate from yesterday, but the effect of Section 2.1 means that any individual who is unaffiliated with a social media company, doesn't matter how big their following is, it doesn't matter how much money they make, they are not, because of 2.1, to be considered a broadcaster for the purpose of the Act. So again, even if you have millions and millions of followers, because of that provision, it's not a question of you being considered a broadcaster. So again, for the most part, individuals are not going to be would not be participating in CRTC proceedings because the Act will not apply to their activities on social media services, for example. But what I would say, Mr. Aitchison, is that what we see in this space is that you have organizations who come to the table to represent the public interest, or organizations or individuals who may not be sophisticated corporations who can hire legal teams to represent them, right? So a good example in this space is an organization called the Public Interest Advocacy Center, for example, that raises many of these issues on behalf of organizations or individuals. And one of the things that the government is proposing to do in Bill C-10 is to ensure that there is actually better support for public interest representation in CRTC proceedings, because right now there's no formal mechanism really that the CRTC has to ensure that the activities of these organizations can be funded. And if you look at Bill C-10, one of the purposes for which the CRTC can seek contributions is to support the participation of public interest organizations in CRTC proceedings. And the government's doing that very intentionally, recognizing that obviously these need to be organizations and voices at the table. And the goal in that is to secure a more long-term sustainable support so that those organizations remain viable and can continue to bring those issues to the table and to CRTC proceedings.
Okay.
Okay, thank you.
Thank you, Mr. Aitchison. Before we go any further, I know yesterday I should have mentioned this, but I'll say this again right now. For those who are watching outside and are watching us through the web, through the internet, the person you just heard talking is, we call him Mr. Ripley. I should probably explain to our viewers who exactly he is. He's from the Department of Canadian Heritage. He is Thomas Ripley. He is the Director General, Broadcasting, Copyright, and Creative Marketplace. I should have done that yesterday. My apologies, Mr. Ripley. You've been a bit of a mystery man to a lot of people watching over the past day and a half, but now you're not. Mr. Reyes, you have the floor.
Merci, Monsieur le Président, et sur les bons mots que...
Thank you, Chair. And on this kind introduction of Mr. Ripley, I would like to thank all of the officials who have been working with us at all meetings, Mr. Ripley and all the others who were in attendance with us each time, from the Commission for people who are there to give us advice and information. And even if we don't always agree with you, your advice is judicious and you do help us to understand the issues with our relative levels of skill and understanding. So thank you again, Mr. Ripley and all of the others. Mr. Ripley, I'd like to ask this question of you. The proposed amendment that I'm making, in what you're saying, would imply you're implying that it wouldn't be necessary. But there's a proverb, I'm not sure how we can say it in English, but meaning that something really solid won't break. Because right now in C10, there's an issue in terms of freedom of expression. Some people feel that we're going too far or that it's not really something that's in danger, but others feel that, yes, there is a crack there. There's a potential breach. And others are saying that CRTC won't go there, but then the bill could enable them, according to several experts, to go there. So my question is, why not oblige the CRTC? Because once it's done, we're going to be hearing the same things from politicians who are going to be in power. They're going to say, oh, it's the CRTC, they're independent, they make their decisions. Every time there are any issues on the subject, we've seen this with the issue of user fees charged, and we saw major and minor organizations. We talked about the issues in digital, the whole digital issues, that there's no power once the CRTC has made their decision because supposedly they're independent. But the committee has seen that even when there should be independence, the government was able to interfere. So I have to wonder, is there anything bad in what I'm proposing? Is there anything wrong in this amendment? Is there anything that would cause harm? Or perhaps I'm asking for more protection, but in the current situation, I think it's justified to request more protection, because after the CRTC will have 9 months to do its work, and then they can table something, and we will not be able to influence anything at that point. We won't be able to influence the way that they'll be governing themselves afterwards at that point. So my first question is, how could I phrase this actually? Is there anything counterproductive in this? I am making a request, and is this something that's going to go against common sense? Or, yes, maybe it's overprotection, but okay, fine, all the better. We can give ourselves more benchmarks to ensure that the CRTC, in this new environment we're working in, will guarantee that every time there's a digital decision, freedom of expression will be protected, and they can publish it on their website. And lobby groups and interest groups and university professors who are interested in freedom of expression could provide reassurance by analyzing this every time there's an amendment in the Gazette.
One moment, please. Mr. Aitchison, point of order.
I'm loath to interrupt my colleague, but the bells are ringing in the chamber.
Yes, they are.
And I just thought maybe we should be aware of that.
Yeah, no, I was going to interrupt Mr. Reyes, but I didn't want to until he got to pose this question to Mr. Ripley. I didn't want to get in on that, but yes, he is right. We have 26 minutes and 50 seconds to vote. As you know, the bells are ringing. The routine is very simple. I need unanimous consent to continue for perhaps another 10, 15 minutes if you so desire. But do I have unanimous consent to continue? I need someone to voice.
Non, je continuerai après, Monsieur le Président.
No, I'd continue afterwards to continue as agreed.
So we're going to suspend until after the vote. And don't forget, if you're delayed from voting coming back on screen, could you please let us know that you're coming, so that way we can do this as quickly as I can. But I don't want to proceed in the committee without everyone on board. The ship don't sail unless it got all. Okay, let's suspend. Again, with clause-by-clause consideration of Bill C-10. When we left off with CPC 9.5. And I have Monsieur Reyes, who was about to ask a question, but you have the floor, sir. Go ahead.
Oui, parfaitement.
Yes, but just before, I don't know if I may, but what has just been voted in the House, it seems to me that with the extension of hours, it means that committees will have an issue of lack of resources. Was this going to be a problem for this afternoon's meeting, or have I been misreading the situation?
Not that I am aware, but you go ahead and do your questioning about this, but we don't have any information on that right now. But trust me, when I do, you will be the first to know. Well, first amongst many. Carry on, sir. You have the floor.
Merci. Merci, Monsieur le Président.
Thank you, Chair. Mr. Ripley, I sum up my question very quickly. The question that I wanted to ask you is the amendment that I'm presenting something that will have a negative impact? Or, as I would wish, is it an additional measure that we are giving in order to ensure that freedom of expression is respected every time a new CRTC regulation is implemented, and that it's respected via sharing information on the CRTC website and a notice in the Canada Gazette? And I'll have another question afterwards. Thank you for the question, Mr. Reyes. My answer will depend on the objective of the amendment. If the objective is to provide an opportunity for people outside to have a legal opinion or to include a legal opinion as evidence in a regulatory procedure, my response would be that this is already the case. There is already an opportunity for people to make submissions to the CRTC. If they would like to submit any legal opinion on the part of a third party, they are welcome to do so. And once this is in the evidence, of course, it has to be considered by the CRTC in its decision-making. If the purpose of the amendment is to oblige the CRTC to publish a legal opinion representing the CRTC's position in this case, I would say yes, that could cause harm because it implies the issue of solicitor-client privilege. That principle is recognized as a fundamental principle in the legal and justice system in Canada, and I believe it's recognized by the Supreme Court. So if the latter is what the objective of the amendment is, yes, this could cause harm at that level. And this is why we see this as an exceptional obligation in the legal system of Canada. Well, you may note my great surprise at this comment, because to ask an organization to give us an opinion saying that they're respecting the Canadian Charter of Rights and Freedoms, and that you're telling us that it would cause harm to this organization in terms of their obligation to confirm matters, we say, and there's an issue like this where there could be challenges. But if I could piggyback on the comment you made, and please confirm this. The CRTC will implement a fund to assist interest groups or organizations wishing to participate in the public hearing so as to be able to ask questions when necessary. Have I understood that correctly when you mentioned that earlier?
Merci, monsieur.
Thank you, Chair. Thank you, Mr. Reyes. Just to clarify the government's position. It's not about whether the CRTC is respecting the Charter. As I've already mentioned, the Charter applies to the CRTC, and there are already mechanisms by which, if people feel that the CRTC has not respected the Charter, there are mechanisms by which they can turn to the federal court to challenge the CRTC's decision. In terms of your question, yes, there is a section in the Act. It is 11.1 sub 1C, which grants the CRTC the power to create regulations regarding spending. And you will note that in sub C, it's support for the participation of individuals, groups, or organizations representing public interest in the case of a matter before the CRTC under the current legislation. So this has been included in the bill to ensure the continuance of the public groups representing the publics and to provide funding should the need be there for those groups. Very well. So I'm hearing what you're saying, but the intention is noble, the intention to have a fund. But what I understand that this doesn't yet exist. The CRTC would be implementing it with its powers, and it would have these powers under the proposed legislation. But you're saying that groups representing interests or people representing interests, to my mind, that's where the problem lies. A YouTuber, a Canadian citizen who doesn't represent the interests of anybody, but who's an individual who feels harmed or would have any questions about this. And there are thousands of these people in the country. A professor, a citizen, a politician with several followers who shares programming or content. That person would not be able to access, that common citizen would not be able to access the fund because that person is not representing an interest group and it considers that he's being prejudiced. Is this incorrect, Mr. Ripley? Thank you, Mr. Reyes. Perhaps I could respond with 2 points. There is already a fund to support participation, public interest participation in the legal process of the CRTC. In the case of broadcasting, it's the Broadcasting Participation Fund. The issue here is that there's not really long-term funding to support the activities of the Broadcasting Participation Fund. But this fund has funded several organizations who have intervened in matters before the CRTC. I gave Mr. Aitchison the example of the Center for Public Interest Defense. This is an example of an organization that is trying to ensure that the interests of Canadians are taken into account. And if you look at their website, their mission, and I'm going to read it in English.
Money and feel respected in the provision of regulated services. And the vision of the organization is to ensure no Canadians are taken advantage of in the provision of essential needed regulated services. Donc, et on voit que le PIAC est très actif dans les...
We see that PIAC is very active in the CRTC processes and proceedings. We recognize that there is a funding issue in terms of the Public Interest Advocacy Center. So to have the Broadcast Participation Fund that would ensure the participation of these organizations in the long run is the reason for which we included 11 sub 1C to be sure that the CRTC will have this power going forward. Very well. So during the study, when we heard from witnesses, no representative of individuals who were on social networks took the floor. They weren't invited. It wasn't part of the initial bill. It was only later when we began to work on amendments. So these people, these citizens, a citizen who would have wanted to give their opinions and who feels harmed by the project has had no opportunity to express themselves. So my question, I'm going to cede the floor to my other colleagues who would like to address this amendment. But my question is, a regular citizen, a common citizen who does not represent an organization, could that person access this fund to be able to participate in public hearings? If the question is, are they able to participate and make a submission to the CRTC process? The answer is yes. Of course, I recognize that it requires effort on the part of the individual to be able to follow the process. And it's a regulatory process, but we do see, and there's a good example, for example, when it came to the license renewal of CBC Radio-Canada. This involves a lot of Canadians, and we saw that they were Canadians who made submissions because they had an opinion regarding the public broadcaster. So yes, it's possible. But clearly, it requires effort on the part of the individual to follow the proceedings and the various stages in the CRTC proceedings. Mr. Ripley, when you say that they can make a submission, you mean they can testify or are asked to testify, or do you mean they can make a submission to be able to access the fund to help them in their work of going to make their submissions? Mr. Ripley? I apologize. The question is the funding available? On that question, my understanding is that presently the fund that I have referred to, the Broadcasting Participation Fund, is, I believe, limited to groups and organizations representing consumers who have a non-commercial interest. Could 11.1 be used to create a fund to support the participation of individuals? The answer to that question is yes. The wording of Sub C is support for the participation of individuals or people. So yes, there is that power. But clearly, if there's any wish to move in that direction, it may be required to amend the mandate of the Broadcasting Participation Fund. Okay, so we agree then that the wording as you read it states that these could be individuals provided they work for the interest of others and not for their own interests. So a single individual would have to see this fund modified or amended by the CRTC, so that if I were an individual to ask for that fund to be able to give me funding to prepare for a public hearing of the CRTC, I wouldn't be able to access it unless I represented a lobby group or an interest group. It's not that it couldn't happen afterwards, but as of today, that's not what this makes possible. Thank you, Chair. Sub C, the intention behind Sub C is to ensure the representation that is in the public interest. So if it were to be used to support an individual, clearly that person and that person's participation in a CRTC proceeding would have to be connected to the public interest. If it is to represent their broadcasting activities, again, on this point, I would emphasize that in the vast majority of cases, we would not have an individual who would be who would be considered to be a broadcaster. If it's an individual using social media, Section 2.1 is very clear that they are not considered to be broadcasters, and so they would not be subject to the jurisdiction of the CRTC. So it doesn't matter about how many subscribers they have or the revenues that they earn. So again, an individual who has a very large following on social media, there's no question of them being subject to the CRTC's jurisdiction as a broadcaster. Very well. Thank you very much, Chair.
Fields.
Thank you, Mr. Chair. Appreciate that conversation. There are just a couple things that come to mind. I mean, recently, CRTC was in the news when they said after Thursday decision, the regulator essentially set aside rates established in 2019. The reason to bring that up is when we talked about transparency, and so this amendment to me leads to more transparency. Because we've had a decision that was made and in the news recently that there's no minutes, there's no recorded votes. You don't know what the discussion was. Now, when they've had the open, when they went through with the CBC, there was transparent hearings. Absolutely. So this concerns me in the sense that this amendment might bring more transparency to the decisions they're making, because now there is no recorded minutes, there is no recorded votes, as compared to when I was involved in municipal government. That's always out there in front, and you have to be very transparent what you do, and it's all on record. And this, to me, provides another safeguard for that. So I think the amendment provides that. Now, Mr. Ripley, I really appreciated your advice and your opinions on this, but that piece to me is important in the sense of transparency, because the CRTC doesn't operate as an elected body because it's an appointed one, and they can be behind that screen that's provided for them. So this to me is another level of transparency that elected people, and I think because we've moved into an area that is going to be very challenging and very interested in the sense of how decisions made, that this amendment would provide just a little bit more of that transparency for the decisions and what they're doing. I don't think it is now. As a body, as a board, they can have all sorts of discussions, no minutes of those discussions, no records of votes, and the rationale for what they're doing. As this recent decision a couple of weeks ago, a week ago, that was very controversial, then they changed from their 2119 decision to the one they suggested the other day. And that has, again, created lots of discussion out there on both sides. But there's no background information that I think that what we're talking about with this amendment is having a legal opinion out there and having it public and in the Gazette. I think it would provide more of that level of transparency. It was what we need at going forward with this piece of legislation. Thank you, Mr. Chair.
Okay. Mr. Waugh.
Thank you, Mr. Chair. I'll be very short. A number of us on here were former members of ACTRA, and they're heavily lobbyists, of course. But I bring that up because...
Le règlement, Monsieur le Président, on n'a pas la caméra de Monsieur Waugh. On ne voit.
Point of order, we don't see the lovely face of the speaker. We don't have a camera on him.
Mr. Waugh,
I totally apologize. I totally apologize. FaceTime, right?
Now you just made everyone happy. Go ahead.
That's right. Good. Thank you, Mr. Chair, and thank you, Mr. Shampoo, for pointing that out. So I will say that a number of us on here were probably members of ACTRA at one time. Whether you had a cooking show or whether you were on CTV or wherever, but we didn't know what ACTRA did. And they were a heavy lobbyist group to the government. Many of their interventions to the CRTC as employees paying dues to ACTRA, we never knew what was going on. And we still don't to this day. And that's wrong, because when you do pay dues, you always find out maybe a year later, but you never find out when they do make an interjection on the behalf of the members. And so I think Mr. Shields was right, and Mr. Reyes, that at times you find out something, but it's always after the fact. So, and I just wanted to bring that up. And Mr. Ripley, you've done a very good job here this morning explaining, the YouTube thing, because there's many I think, out there in listening today that would say the CRTC makes too many small decisions for getting a legal opinion to be practical. And you talked about that. And there are those decisions in the online sphere that could not be taken lightly at all. We see today in free speech, and we don't want them to be able to quickly make hundreds of algorithm changes every day without proactively checking for charter compliance. So, I make that point because, we're going to go after YouTube here and others. But Mr. Ripley, I'll just, if you can explain a little bit about it. I think you've done a very good job here this morning explaining parts of this, but I think when you look at YouTube and a single user taking on ACTRA and CDCE and other organizations, you can see where the concern is, because a single user that needs maybe clarification going up against these other organizations, well, I mean, there's an imbalance there right away. We would know that. But do you just want to comment a little bit on that? I know you've explained it pretty well, but is there anything else you want to add, Mr. Ripley?
Mr. Ripley.
Thank you, Mr. Chair, and thank you, Mr. Waugh. I might make a couple introductory points, and then actually I might suggest my colleague, Mr. Olson, jump in, who's very well versed in CRTC processes. So Bill C-10 certainly, envisions a transparent process when it comes to questions of regulations or orders. And the intention is certainly that anybody who wants to participate in those proceedings, that they have an opportunity to do so. And so, Mr. Chair, if you permit me, perhaps Mr. Olson can just quickly jump in and explain kind of how this would work in a typical CRTC process and the kinds of things that would be naturally published on the CRTC's website and the materials that would be made available.
Mr. Olson.
Thank you, Mr. Chair. So when the CRTC initiates a public proceeding, it publishes a notice of that proceeding on its website and in most cases in the Canada Gazette. And then it calls for comments. It has rules of procedure around the time periods and the process by which it gets those comments. Sometimes there's even a reply period that the commission would give interveners a chance to reply to other comments. Sometimes there isn't, but that's governed in the sort of CRTC's rules of procedure. And then, so the CRTC then takes all of those submissions and it considers only that information that's on the public record, of course, subject to any information that was filed in confidence, and then it makes its decision. And anything that's filed in confidence, the rules say there must be an abridged version without the confidential information filed. So that's usually just financial information. It's usually just numbers that get that get blanked out. But all of that information is available to all the parties other than the actual numbers. And then the commission takes all that and makes its decision. The decision is always published on its website, and the decision is almost always published in the Canada Gazette as well. So the CRTC, runs a number of transparent, it takes transparency very seriously in that regard, and it is an administrative tribunal, and so if it has failed to follow any kind of due process, then that would be subject to judicial review.
I have one more question to Mr. Olson, if I may, Mr. Chair.
Go ahead,
Yeah,
sir.
so, in the conventional broadcasting, you'll hear an ad run by the radio station or a TV station, saying, submit, if you have issues with the station, please submit here to the CRTC Ottawa. So how would that work in social media here? So, I do have the ad. I know when their license is coming up because well in advance, the station does a 30-second ad. Right. But there are no ads here, or will there be ads on social media? Explain this process to me, because conventional TV, they do a pretty good job when their license is coming up. And if you have issues, they do direct you to the CRTC.
Mr. Olson.
Thank you, Mr. Chair. Thank you for the question, Mr. Waugh. So those commercials that you referred to are commercials that are part of the license renewal process and are an obligation that the CRTC imposes on licensees to make public the notion that that the license is being renewed and that people can make comments on the conditions of license. The situation, of course, in Bill C-10 is that the proposal is to move away from a conditions of license model and towards a conditions of service model. And so the CRTC, in the clause that this committee is currently debating, clause 7 of the bill, which would include section 9.1, it does give the CRTC the powers to make orders with respect to conditions of service that would need to be put on. And so the CRTC would, under the sort of umbrella, the chapeau, if you like, of section 9.1, would have the ability, if it chooses to make requirements related to related to CRTC proceedings, like advertisements of various CRTC proceedings, if it chose to do so. That, of course, also depends on what this committee ultimately and this parliament ultimately decides to do on whether or not conditions of service will be sort of automatically renewed not automatically renewed, have a 7-year maximum duration, or whether or not those will be subject to different periods of review. But I would think that the Bill C-10 does give the CRTC the power to require at any time that significant conditions of service are being looked at by the commission, to require that messages be broadcast by licensees to that effect.
Mr. Olson, that is the concern I have with the 7 years service, as you know, because every conventional TV radio station in this country starts advertising.
Point of order, Mr. Chair.
Point of order, Ms. DeBruzen.
So I kind of let it go for a while because we were talking about, legal opinions in the broader context, but now we're talking about conditions of license, and I believe that the amendment we're looking at is about independent legal opinions for all, basically all decisions from the CRTC. I'm not paraphrasing it, but there you go. So perhaps if the questions in the conversation can focus on that amendment, that would be good.
Okay, Mr. Watt, yep, go ahead. I'm assuming that your arch, as wide swinging as it can be at some point, will come back to the center. So you still have the floor, sir. Go ahead.
No, thank you, Mr. Sims, and thank you to MP DeBruzen for the reminder. I appreciate that very much. Thank you, Mr. Olson, because you've put more questions in my mind now than ever with your comments, but I will just leave it at that. I just hope that people in this country go to the Canada Gazette, because I never did in 45 years of broadcasting. And so I hope that everybody in this country realizes that the CRTC does exist and Canada Gazette will be their mouthpiece. So I just thought I would say that. I really like this amendment by Mr. Reyes, as you know. I think we have to, and all parliamentarians agree, that the independent legal opinions are very important in this, and that's all I'll say. So thank you very much, Mr. Olson and Mr. Ripley, for your time here this morning.
Mr. Aitchison.
Thanks, Mr. Chair. I actually want to discuss the Broadcasting Participation Fund again with Mr. Ripley. Just because it does relate, Mr. Brusen, to this concept, and I hate to think that maybe I'm offending some sensibilities about keeping to point. But I'm wondering, and I don't suggest for one second that you have such things memorized or have access to them right now, but I'm wondering if we as parliamentarians have access to sort of a breakdown of what the budget is, for example, of that Broadcasting Participation Fund.
Mr. Ripley.
I thank you, Mr. Aitchison, for the question, and you are right that I don't have that figure at the tip of my fingers. What I can say is, the fund has had a multi-million-dollar budget over the course of its time in the course of its existence. To date, it has been funded sporadically by what are called tangible benefits decisions. So when the CRTC approves certain transactions, one company buying another, they divert or require some of the proceeds from that transaction to go towards supporting public interest objectives. And so that is how the Broadcasting Participation Fund has been funded to date. The challenge is that there's really no sustainable funding source in place, and it is quickly actually its coffers are getting low. So again, one of the reasons the government included this power in 11.1 was to ensure that the CRTC has a lever that it can use other than tangible benefits from transactions to support things like the Broadcasting Participation Fund. But they have supported a number of different interveners in broadcast proceedings over the years. They do publish an annual report that I think is available on their website, and we can certainly get you the link to that if that's of interest.
Thank you. It actually really would be. I'm actually very interested in this, just because I think that, well, I suspect that the need for it's going to grow based on what we're doing. So, big government, bigger programs to, help people fight big government. So anyhow, if you could send a link to that information, that'd be really helpful. And I'm glad that I entertained Mr. Bruce in there with my final comments. And that's good for me. Thank you, Mr. Chair, for allowing that question.
Thank you. Mr. Shields.
Mr. Chair, point of clarification. For those on the committee and those listening, you're referring to a clock and you're referring to timing. Could you clarify what would occur when that clock runs to zero?
When it runs to zero, we proceed directly to clause by clause consideration, and there'll be instructions with that as we go along. As you know, based on what we received from the House that the majority of the members voted on, we have our instructions. So 5 hours debate, then we go straight into clause by clause.
Clause by clause in committee?
Correct.
Okay, thank you.
Oh, sorry, was that it? Mr. Lewis.
Yes, thank you, Mr. Chair. I appreciate the time. As far as clause CPC 9.5, I think we've discussed it in length, and I'll still maybe have another question at the end of my comments, but I believe that would just really slow down the process. And from the beginning, we've heard from stakeholders, we've heard from experts that updating the Canada Broadcasting Act is necessary to include digital platforms, and that we can't spend more time doing this. These digital platforms that act as broadcasters have to be subjected to the same legislative and regulatory conditions that apply to traditional Canadian broadcasters. And every day that things get slowed down, our artists are losing income and by not having a level playing field. And so, and I know this from personal experience, and I've sat here and I've listened, and I've heard members from the other side now starting to attack some of the organizations for the lobbying, ACTRA or SOCAN or others. These are the same organizations that actually many of us, let's say, belong to or had belonged to, and so do I. And they make up the arts industry and the cultural industry in our country, and we have an obligation to support them. Making art takes years of dedication, and that requires support. We get more of what we support, and we get less of what we don't. And so we need to move forward in a quick way, and most of us on this committee have done that. But my concerns are that some members are taking the side of these big tech companies opposed to our arts community, and especially during a pandemic when they're struggling. Every stage in the world is dark, and people couldn't perform, and they were relying on that passive income for the writing that they're doing, for the performances, the things they're putting on Spotify and YouTube, and all they're asking for is a level playing field. And when one of the members in an article in the Lethbridge Times, I believe, said that they referred to these artists that relied on government grants to continue to exist, that are producing material that Canadians don't want, those are our neighbors. Those are our Canadian artists. And we deserve to move as quickly as possible to level this playing field and give them the chance to make a living.
Okay. One moment. I have 2 points of order. I have Mr. Waugh first and Mr. Reyes. Mr. Waugh?
Well, thank you, Mr. Chair, but nowhere is he talking about the amendment that we're bringing forward. You know, I got called on it about 5 minutes ago, and
right. Okay.
I can see the members not talking about what we have, the reference 6200 in front of us. So
I'm generous to an exponential degree. However, Mr. Lewis, with the wide arc you're swinging, I hope you are. I'm assuming that you're coming back to the point of the amendment as you first started out by talking about 9.5. In the meantime, I also had Mr. Reyes with a point of order. Was that the same topic, Mr. Reyes?
C'était le même.
It was the same topic, but Mr. Waugh did refer to it. I wanted to request the adjournment of the meeting because we have another meeting this afternoon. There's question period, and we would like to have a chance to eat something because yesterday we all skipped our supper.
Yeah, I'm hungry for the muffin as well. However, two things there. Number one, as far as your point of order is concerned, okay, but you did raise a point of order, so I can't let you move a motion to adjourn. However, that being said, we are slightly 5 minutes past. I do provide leeway towards the end for folks who'd like to come back from voting back into, so there's a lag time there. We are under implied consent, as I've said many times, around 1 o'clock. Mr. Lewis is in the middle of his thoughts. I like to let people finish their thoughts, and then we make a decision from there. Mr. Lewis, you have the floor.
Thank you, Mr. Chair, and I appreciate everyone's need to let free speech be a thing. And I can tell you right now, as an artist myself, artists on the front line of free speech, and believe that everyone has a right to be heard. And as far as some of these amendments, I think CPC 9.5 would bring things to a standstill as far as decisions that were up for review. However, in a broader stroke, this is not about free speech. This is about supporting artists and being a level playing field. So I wonder in my final questions if Mr. Ripley would give his opinion if he thinks that the CRTC and their independent legal counsel is sufficient in where it's at right now.
Mr. Ripley.
Thank you, Mr. Chair, and thank you for the question, Mr. Lewis. The government position is that the CRTC is bound by the charter, needs to respect the charter, and its independent legal counsel will help them do that. If ever there is a question about them not having respected the charter, there are meaningful avenues of recourse available where individuals or organizations can have oversight from the federal court system. As I indicated to Mr. Reyes, if the objective is to make sure that there's a way that third parties can put legal opinions on record and have them made public and have them be considered by the CRTC, the government's position is that is already able to happen under the framework in Bill C-10, as Mr. Olson outlined. There is a process whereby anybody can make a submission to any kind of CRTC proceeding, and therefore, if there are individuals or organizations who want to put on record a legal opinion that speaks to the issues of charter and have that be part of the public record, part of the proceedings that the CRTC must consider, then there is a way for them to already do that under Bill C-10.
Thank you. If I can ask a quick question, Mr. Ripley, between, let's say, some of these amendments that we're talking about now or Section 2.1 there, individual Canadians who use social media platforms are not subject to regulation by this update of the Broadcasting Act. Is that correct?
Mr. Ripley.
Yes, Section 2.1 provides that individuals who use social media, those individuals are not to be considered broadcasters for the purposes of the Act unless they are in some way affiliated with the social media service. And again, that is irrespective of how many followers they have, even if the count is into the millions, or how much revenue they make. They are not to be considered broadcasters under the Broadcasting Act and are not subject to CRTC jurisdiction thereof.
Great, thank you much. As a committee member here.
Point d'ordre, Monsieur le Président.
Point of order.
To order, Mr. Reyes.
Oui, je sais pas si Monsieur.
I don't know whether Mr. Lewis is almost finished, but it's now more than 8 minutes past the ending time. I know we can't interrupt him. You want to let him finish. There's going to be another meeting this afternoon, and he can get his 5 hours. No worry about that.
Okay, Mr. Lewis, back to you. You have the floor.
I appreciate that, Mr. Chair. I've been waiting a while to get my comments, and I will simply close up by saying that that as an artist, I'm going to continue fighting for artists, and many of the people in this room are. I have no problem going back to my constituents and saying that we've stood up for our arts community. I certainly hope that everyone in this community has the opportunity to go back and talk to their arts stakeholders and see what they have to say. Thank you for your time.
Mr. Shields.
Motion to adjourn.
Madam Clerk.
Yes, sir. Motion to adjourn the meeting. Mr. Housefather.
Yes.
Madame Bissett.
Oui.
Ms. DeBruson.
Yes.
Ms. Ian.
Yes.
Mr. Lewis.
Yes.
Monsieur Reyes.
Oui.
Mr. Aitchison.
Yes.
Mr. Shields.
Yes.
Mr. Waugh.
Yes.
Monsieur Champoux.
Oui.
Ms. McPherson. I'm sorry, Ms. McPherson? There's no sound. Can you lower your boom, please?
Yes, sorry.
Thank
I was
you.
drinking coffee.
It's 11 yeas, sir. Mr. Sims?
Sorry. Sorry about that. The coordinates, the Zoom coordinates for this afternoon's meeting has been sent to your inbox. And in the meantime, we'll see you at 3:30 Eastern this afternoon. Meeting adjourned.
How many hours left? Okay.